My guest has fought in battle, not just in courtroom battles, but he's actually fought in battle for our military. He's earned 2 Bronze Stars for heroism and a Purple Heart. He's commanded artillery batteries. He served in the United States Marine Corps and as a JAG officer representing soldiers who were accused of crimes. He's a criminal defense lawyer of the highest level, and he's practiced alongside legendary criminal defense lawyers such as Racehorse Haynes and Dick DeGuerin. He's won acquittal after acquittal in some of the most high-profile cases in Texas and across the United States, and even interceded and represented the chief negotiator for the Branch Davidian religious group during the standoff with the FBI after the ATF raid. And he testified in Congress about the events of that incident. If you wanted to meet a hero, I've got it. My name is Neil Rockhind. This is the Killer Cross-Examination Podcast. My nickname is the Rockweiler for my unique, fiery, and aggressive courtroom style. And my guest is none other than legendary trial lawyer, criminal defense lawyer, and American hero, Jack Zimmermann. Jack, welcome to the Killer Cross-Examination Podcast. All right, Jack, you have quite a storied background. Tell me, if you would, first of all, give me some background about where you started, kind of where you think the principles that led to you becoming the fierce trial lawyer that you are. Where did it all begin?
Sure. I think that not just in the specific answer to that question, but I think everybody is influenced by their upbringing, if you will. And so I think some of the attributes that I developed as a trial lawyer and as an appellate lawyer began back when I had one of the greatest high school football coaches who was very, very demanding. And I learned at that time how to overcome adversity, to persevere, even when we were getting beat, work through pain. And then I went from there to the Naval Academy through what's called a plebe year, your freshman year, where there's someone in your face almost all day, every day, criticizing you and critiquing you. And you have to learn how to respond to pressure, which is done on purpose, so that the future officer is able to respond in combat without having to blink an eye. And so that went on for a year. And then for the next 3 years, I was competing with other midshipmen who also passed the highest standards to get in the first place, both academically and athletically. And my last year, I was selected for a leadership position. So I learned a great deal about leadership while still at the Naval Academy. And then when I graduated, I went into the Marine Corps, which I think probably influenced me just as much or maybe more, and learned the necessity to accomplish the mission, which translates into being a trial lawyer as well, I think, and to how to care for your subordinates, which carries over even today into my leadership position, if you will, at the law firm. And I can tell you that on a regular basis, I get calls, letters, emails from former law clerks who learned how to be a lawyer by clerking for our law firm usually for 3-year period, and are now federal district judges, state district judges, prosecutors, successful defense lawyers all over the country. And being in the Marine Corps, I learned how to adhere to rules, which trial lawyers have to do. I had respect for seniority, which trial lawyers and appellate lawyers have to show that respect to state district judge. He was asked to comment about me being in his courtroom, and he said that he was able to look at my performance in his courtroom, and he could see me formulating my plan of attack as if it were a military operation in his courtroom. So obviously it was obvious to them too. And then
is that sort of how you approach your cases? Do you have that that organization, that sort of battle plan that you're, I guess I'll just call it like a chess game. Are you sort of seeing the moves ahead of time and figuring out your battle plan?
I do. And I'm a big proponent. I always say that no one wins a case in the courtroom. You win your case by preparing prior to trial. So you win it in your office. If you go to trial and you're not prepared, you're not going to win. And so that's the same as having a plan. In the military, we'd call it an operation plan, which, by the way, I don't know if this is the appropriate time to say this, but I have a sort of what to me was a light experience about that issue. Many years later, after the WACO fiasco, I was testifying in a congressional investigation into what happened there. And my whole point was, before the pre-hearing investigation hearing occurred, I had to submit an opening statement and in writing, and I had fiercely criticized the department, the ATF, the alcohol, tobacco, and firearms, for making an assault on the WACO situation without having an operation plan that made sense. They were claiming that they had intelligence that the Branch Davidians had machine guns in there, and they send in a truck of ATF agents with nothing more than canvas cover and no fire support or anything like that. And so during the hearings, they asked me what I thought about the plan that the ATF had. And I said, well, let me just put it this way. Quantico, Virginia is 30 miles south of here, and that's where all Marine officers go for their initial training. And they're taught how to develop an operation plan, which is what you and I were just talking about. And I said, you know what would happen to a Marine lieutenant if he submitted the operation order that the ATF used that day in Waco? And the congressman said, no, Mr. Zimmerman, what would it be? I said, if he submitted something like that, he would get transferred to the Air Force. And of course, that cracked everybody up, but it made the point. You know what I'm saying? So anyway, back to what we were talking about.
Let me ask you a question. So for
Sure.
a lot of people who don't know, I would like to brag on you for a couple of minutes so people have some idea of where you're coming from. I know that you graduated from the United States Naval Academy, and then you went on to graduate from Purdue University. You ultimately got a Doctor of Jurisprudence from the University of Texas.
Yes.
You served in Vietnam, and you earned 2 Bronze Star medals for heroism and a Purple Heart. And you retired as a colonel from the United States Marine Corps Reserve on July 1st, 1994. You served in several capacities. I mean, this is impressive stuff. In General Court Martial, Trial Judge, Commander of Inspector Detachment for Marine Reserve Ground Forces. Married over 56 years to Eileen. That probably wasn't much of a battle.
Very big influence, though.
Very good influence. You have been named, and I'm just sort of skipping through, you've been a board certified in criminal law by the National Board of Trial Advocacy. You've been a partner in 2 different law firms, it looks like. You've been named a super lawyer since super lawyers started giving out the cape and the little, S law crest. Lawyer of the Year. You've received an award called the Warhorse Award. I think probably do an entire segment just talking about your awards.
Well,
one of the things that was the most impressive to me, which I didn't know before we started talking, was that the number of hugely significant cases that you have taken on, and I didn't know that. I will confess, I should say, I had a young man who shared with me that I ought to talk to you. I had a very good friend of mine, Jerry Goldstein, who said, you need to, oh yeah, Jack Zimmermann, he and I went on our first, double date together.
I've seen a lot of stuff.
And I'm looking over your career, and it is impressive as hell, Jack.
Thank you, sir.
I mean, this is service. I mean, you have really served. You've served the military, you've served the country, you've served the community, you've served the law. And I just want to say hats off to you. I don't want to give you one of those, people always pass by, thank you for your service. But I mean, this is real. I'm paying homage to this. I could talk about your service. You have more listed in your bar and civic activities and personal background than most people have on an entire resume after 50 years.
Well, thank you very much. Let me follow that up because it was what we were talking about before you went into that. And we have to make sure everybody that's watching knows that I did not ask you to do what you just did.
No, I'm blown away by some of the things that you have done, and you've taken on some unpopular causes.
Yeah.
I'll say unpopular but I view that as something you must consider as part of your duty, as part of your responsibility.
Yes, let me leave
popular case.
the portion of the interview that's dealing with background and how it influenced my career by saying that my service in the Marine Corps developed in me even further a love for our country and for our Constitution, because those unpopular cases, like representing people convicted already of capital murder, or representing the Branch Davidians in the WACO matter, and several other, the young Marine that was accused of murder on a border shooting case. We can get into all those things later if you want to, but that came from my Marine Corps background. And so I think that did influence and does influence to today why I take those cases. You don't make money on most of those cases, are either pro bono or at a very low fee. And I think that people, not just me, but people who do what I do that because we love the country and because we love the Constitution. And so I sometimes refer to myself as a constitutional lawyer, because I think that when a defense lawyer goes before the bar and before a judge and jury, that's what we're doing. We're representing the Constitution to make sure that the Constitution applies to every single person brought to trial, if federal, state, or military in this country, and that the U.S. Constitution and the state constitutions apply. It's our job to make sure that they're followed.
Now, Jack, let me ask you. So those are important sentiments, because there are some people out there that don't share those. And as our country becomes more and more polarized, it's hard to find something that we all have in common. We used to always root for the Olympic, the USA Olympic team to succeed together. It was a rallying point. We used to always rally around the underdog. We would rally around each other if there were illnesses and it's becoming harder and harder to see that sort of commitment to what is the greater good. That seems, though, something that you really believe in, that we have to be in this all together. And so a guy like you has to take on some of these cases in order for the rest of us to enjoy the rights that we have. Is that how you view it?
Yes, I don't think that we represent only individual clients in the case of in point that's going on. I think what we do, all of us, not just me, but all of us who take the oath to uphold the law as lawyers, we're representing the whole community to make sure that the trial in session at the time is conducted in accordance with the Constitution that applies to everybody, regardless of what race, what gender, what part of the country, what economic status. Everybody deserves the right to a fair trial. And that's what we're committed to, we defense lawyers. And of course, I've been a prosecutor too. And I have to tell you that when I got selected to be the chief prosecutor of the 2nd Marine Division, which I always have said is the most conservative jurisdiction in the country, 2nd Marine Division, prosecutor, they sent me to the career prosecutors course conducted by the University of Houston. Back then, there were prosecutors, young prosecutors, new prosecutors from all over the country in that course. And the head of the course.
I was there as well.
Oh, good. Well, you know what I'm talking about. The introduction of that was, he said, I want all of you people to know that the most important and most powerful person in the United States is the prosecutor, the public prosecutor, because you will hold in your hands the future and a life of the people that you're going to be prosecuting. So don't abuse it. you need to recognize that if you indict somebody, you better have the proof beyond a reasonable doubt before you indict somebody, because you're going to ruin somebody's life if you indict an innocent person. So you need to be, impress us right from the beginning of how important our job was. I passed that on. And I will tell you, when I was the head of that prosecution unit, there were many cases where I'd call the prosecutor in and say, I've reviewed this case. I want you to tell me why you think you have proof beyond a reasonable doubt, because I don't see it. And they would have to show me that there was proof beyond a reasonable doubt before I permitted them to proceed with the case. I wish all prosecutors did that today. And I think that that's the that's the charge that's in the U.S. Attorney's Manual that applies to all federal prosecutors throughout the country. They're not supposed to proceed with a case if they don't think they have proof beyond a reasonable doubt. Probable cause is not enough. Although under the law, probable cause is sufficient to warrant an indictment.
Hey, Jack, let me ask you this. So you started off you started off actually trying cases before, was it a military, before military judges, were they Marine judges, military judges?
Yes. And that was one of the things I was going to go into when you thought it was appropriate. But I thought that was a formative thing. My first stage was when I graduated from law school and got sent to my first duty station, I got to pick whether I wanted to be a defense lawyer or a prosecutor, because there were openings in both of them. And I think, like any other young, gung-ho, hard charging graduate from law school who thinks you're out to save the world, like I did, that you would choose the defense, right? So, based for all the reasons we just got through talking about. So I got to pick that. And so I learned how to try cases before very conservative Marine Corps active duty judges and before Marine Corps active duty juries. So, that's how I had my teeth were originally in the beginning, with having to make sure that we followed every single rule, and a respect for the judge was omnipotent in the courtroom, and we had to have that's where I learned to develop the procedures that had followed me all the way through, even to today.
Jack, when you were in those, is there a difference? So I know most people don't have a lot of familiarity with what a military court-martial or a military tribunal is like. They've only seen them in a couple of movies, Rules of Engagement, and probably A Few Good Men is the one that stands out. Is it anything like those movies?
Sort of. The intent was, in 1951, when the Uniform Code of Military Justice was enacted by Congress, there was a reaction to World War II military justice, which wasn't very just. And so it was they tried to incorporate many constitutional provisions into the military system so that they would protect those rights that you and I just been talking about. For example, Miranda is based on some not Marine Corps, but military case law that preceded the Supreme Court establishing the rules for the right to counsel, right to remain silent, and all that stuff as being constitutional rights. The military people had that a couple of years before Miranda came out. And that's continued. There are some differences that people think at first glance are not favorable to the defendant because of military necessity. For example, the only right to a 12-member jury is in a capital case. And there are lesser numbers required for felony cases and misdemeanor cases, which are called general courts martial and special courts martial, in a broad sense. And that's because of the military necessity of having to have a system that can function not only in peacetime in the United States, but in wartime in a foreign country. So there are differences. The number of jurors, not a requirement for unanimity except in capital cases. So, and then there's been this recent push in the last 3 or 4 years to make it even more like federal district court cases. And there's been some pushback that's going on right now. The commanding officer, known as the convening authority in the military, currently has the final authority about whether a felony case goes to court-martial or not, based on the advice of his senior lawyer, called the staff judge advocate of that command. There's an effort in Congress right now to take that authority away from the commanding general or the commanding officer and put it in the hands of a quote professional prosecutor or a lawyer, and create special chief prosecutors for all these things and leave the decisions to that person. We won't get into that. That's highly contested and subjected to. And
oh, I get that. I want to ask you. So I tend to just kind of take the conversation where it goes. And you happen to have mentioned that you were involved in the United States versus David Koresh, what we would commonly call the WACO or Branch Davidian case.
yes,
Would you tell me a little bit about that? First of all, who did you represent? Let me start from the beginning. Did you watch the events unfold on television as they were unfolding? And
my initial information about it was, yes, I saw what I call the initial attack on the first day on a television tonight, and to make a really long story shorter, I represented Steve Schneider, who was the minister trained, theology trained assistant to David Koresh, but he was the interface with the FBI and the other authorities. And so he was technically my client, but I felt like I was representing all of the people who were trapped in that situation when the FBI took over and encircled it, and nobody could come in or out without their authority. So I was representing Steve. Theoretically, I was representing Steve Schneider, who was killed on the day when I call it the church, the government called it the compound. They put military terms on all of these things, which wasn't what the intent was when the building was built and occupied. And then my involvement after that. So I was watching. The day that thing came, I got in my car and I drove there and checked into a hotel, and I was there for a good part of the time until I thought we had the case resolved and no more life would be lost, and that we had reached an agreement with the FBI, and I thought we had. And then I came back, and then I wake up a couple of days later and I see the place burning, and it was just a devastating thing. One of the lowest points in my career, because we had negotiated what they called a surrender, and I don't object to it being called a surrender, but we had a peaceful resolution to it, so no more life would be lost. And then as a result, we had 80 people get killed and get burned alive, and it was just the biggest tragedy of any case that I've ever had. I wasn't able to resolve that.
You ended up testifying at a congressional hearing.
Yes, I did.
Is that your first time testifying at a congressional hearing?
First and only one. Yes, sir.
What was that like? First of all, I'll tell you the reason why I asked. I have watched senators and congressmen question important witnesses and have walked away almost, I'll say, unimpressed, right?
Okay.
Like I watched them walk away almost unimpressed. 5 minutes of questions, none of which are answered. I yield back my time, take back my time. I mean, it's just, it's so partisan. It's not probing. It's not good questioning. It's not exposing the witness to anything. What was your experience when you were testifying before Congress about this very important matter?
Well, the first thing I could say is I saw that there was a traditional break between one party and the other, and I don't want to get into politics, but I think that politics did play a part in that, because the party that you would normally think would be very conservative was trying to uphold the law enforcement, and the party that was usually the other way was on the other side of it. So I have to say that I thought that this was a joint committee of both House and Senate. I thought that some of the questions were really great. I thought some weren't. And I'll give you an example when you tell me it's time to do that.
Time.
It's time? All right.
Yeah.
There was this fella from Mississippi, a congressman from Mississippi. I won't tell you his name. He's distinguished by this hairspray hairdo he had. It would shine, and he was trying to make the point that this was a military operation, and that we should defer to that. So he starts asking me these questions without having read my damn written pre-hearing statement. He said, "Mr. Zimmermann, I don't suppose you ever had any military service, did you, sir?" I said, "Well, sir, yes, I did. I just retired last year as a colonel in the United States Marine Corps Reserve after 30 years. "Oh, well, thank you for your service." And then he was trying to show that if I had children, I wouldn't have exposed my children to things. He says, "I don't suppose you have any children with military service." I said, "Yes, sir, I do." I said, "Right now, both my son and my daughter are officers of Marines right now going through training." He said, "Oh, well, thank you for their service." And that ended his questions. And that was one of the highlights of my congressional hearing, I think.
And I think about that because I have had, when I was a prosecutor, I watched some lawyers try some cases, and some of these guys were just totally unprepared. They almost seemed to, in a way, be unintentionally helping the other side during the questioning. Prosecutor would ask some questions of a witness, and so the defense would get up there in an armed robbery case and say, "So, ma'am, you were a clerk?" "Yes." "And you had some items for sale?" "Well, the store did." "And this guy walked in here with a gun?" "Yeah." And he pointed it at you?" "Yeah." "And he did a stick up?" "Yes." So that you're saying that he robbed you. And prosecutor sitting back like, "You're helping me."
Yeah, you got to be careful what you say.
This guy was helping you in a way. He didn't, obviously he had a way of making
it. He wasn't prepared. And that's one of the key things that I say. We don't win cases in the courtroom. We win in our office when we prepare for trial. He was not prepared for that testimony. There was a couple other things. There was somebody who's still very active and in a very, very senior high position in our government right now, was a relatively junior member of the House back then, who happened to be an American of the Jewish faith. And we were talking about the gassing that went on. And I was making the point how horrible it was, in my view, to put CS gas into that building, knowing that there were young children in there, women, unprotected men, no gas masks, and that I said I could just see that and empathize with these young children and these people coughing, choking, vomiting, having no way of escape, and how horrible that was. And it seemed to make an impression on everybody but this one guy from New York, who was saying that I was too critical of what he said. CS gas is not all that bad. I said, well, let me test you. Again, I've told you that Quantico is 30 miles south of here, and all Marines officers going through training have to go through the gas chamber to learn what it's like to go in there with the gas mask, and you can breathe fine and talk and think. Then they make you take it off and count to a certain number, or say certain number of words, so that you have to breathe it in, and then you see what the effective is. I said, that's in a controlled situation. I said, to me, this is as worse than or similar to what happened in the gas chambers during World War II in the Holocaust. And I said, and you shouldn't be talking about this. Someone of your background, knowing that he was a Jewish American, you shouldn't be supporting the federal government doing that to our own citizens. And I think that made an impression on the committee.
I bet
they never did come out with an investigation. Let me summarize my effort. And by the way, I wasn't there by myself. Dick DeGuerin was co-counsel. Dick represented Koresh and I represented Snyder. And we went before them. Dick's a great lawyer and a good person, and he's brave, or braver than I am. So he went through all the stuff that I did, and he testified for that congressional hearing as well, and did a great job, in my opinion. But comparing, I thought I shut down someone who is now a senior senator by making that comparison with the gas and the kids. And I will tell you that as a result of that hearing, in my opinion, the FBI changed their tactics completely when they are dealing with hostage situations. So I think we did some good, even though there were just, scores of people who lost their lives unnecessarily. I don't think it was for nothing. But I do think that had the people in charge listened to the FBI people on the scene back then, when we had an agreement, and I don't know if we got time to go into all what that agreement was, but we had an agreement down to who was going to go in and when, and who was going to come out first. And it would have been a resolution where nobody lost their lives, and the dispute would have been handled in federal court. And some of the survivors that jumped out of the burning building and survived and went to jail and went to court in federal court. I was, in fact, a witness called by the defense because I had been inside. And I had talked to the children ahead of time where all these accusations of child abuse and so forth. And I'm a father and I'm a grandfather. And I think I'm able to determine by talking to a 3 or 4 year old whether that person's been abused or not. There were no abused children in that area and nobody restricted us to who we could talk to. So we talked to them all. We saw how it worked. Almost all of that stuff was in the legalese BS. All right, and it wasn't true.
That's legalese.
So, yes, legalese.
I'm gonna tell the next gentleman in front of that. Jack Zimmermann said I'm allowed to say BS. That's legalese.
Anyway, that was a real. That to me was one of the low points of my career, because I was feeling so good when we walked out of there, because Dick and I had developed a rapport with the leadership of the FBI at that time. And I really believe that they were, the guys we talked to, the special agents in charge at the scene, were really, really disappointed that it turned out as it did. I could tell one of them was holding a press conference and looked at me and was about to break into tears when he was telling people what happened, because he had just gotten through saying, like the day before, that we'd reached an agreement. And so bottom line is, I had a great deal of respect for some of the FBI agents that were trying to resolve it, and a much lower regard, esteem-wise, for the Attorney General at that time for authorizing that damn attack where they killed everybody. Not everybody, but all but a few. And
Jack, let me. So I've had the privilege of interviewing and talking to some great lawyers who've had some incredible results in the courtroom. Few have come from your military background. Some have. I'm curious, and I want to go through some of your cases and some of the results you've gotten, but I think this would be a good time for me to ask you, or you to share with me. Tell me about your style. How I know we've talked about your background, and I can see you have a military background. You're fierce. I can see that you're probably somebody who's not going to be pushed around. But let's start with, how would you describe your style of cross-examination in a courtroom?
all right, well, generally speaking, there's some people that say you want to just be real aggressive and try to embarrass the witness and just destroy the witness on the stand. I don't think that that's going to succeed in almost all of the cases. It's going to be rare that you can destroy somebody on the stand. And what you run the risk of doing, if that's your approach, is to cause the jury to have sympathy with the witness. So I don't endorse that thing. What I try to do on cross-examination is be totally prepared as to any statement that person is given, any statement that somebody else is is contradictory to that to what their testimony is going to be, and try to lock them in to taking a position that you can attack later on successfully. So I believe in being as polite as you can, but firm. And if they're clearly lying, the jury will see that they're clearly lying, and they're going to be more likely to accept your view if they view you as a gentleman or a gentlewoman to try to accomplish that, than rather just go down and try to burn the house down. So I don't. That's my view.
I respect that, and I know that there are some lawyers who go out there and their whole goal is to breathe fire on the witness, and there are others who have a sort of a more strategic view of it and try to thrust and parry when they can. Tell me what you advocate. How do you practice sort of your cross-examination? Let's start with, how do you prepare for cross-examination of witnesses? Do you do it? Do you have a notebook in front of you? Do you have an outline? Do you do it off the top of your head? How do you do it?
All right, first of all, let me seize on the last alternative you suggested. I don't think you do it on the top of your head, okay? Especially not in a complicated case. You prepare each witness's cross-examination based on what you know. If they've given a statement before and you can disprove parts of that statement, you want to get them, nail them down to that statement and then disprove it either through them or some other evidence. But you want to lock them into a theory of what they say they saw or what they think. And I think one of the biggest mistakes young lawyers do is that they write the questions out ahead of time. So they're organized, which I applaud, but you don't want to get nailed to a specific question, the literal question. I suggest you outline what you want to get from this particular witness, and then ask questions based on what answers you're getting to the questions before. In other words, the key thing to me is listen to the friggin' answer, okay? And then ask a question based on what that answer is and make it flow. And not just jump from one section to one subject to the next subject, because that's what's written down on your questions that you write out.
Doesn't that frustrate you when you see lawyers who, if they were actually paying attention, may have just found an opportunity to push further at a witness or into the state's or government's theory of the case, and instead of pushing forward, they just flip the page of their notebook and move on to a non sequitur question. Like, yes, you're sitting there waiting for it. You're like, yeah, okay, the guy just threw a softball to you, you know, and instead of swinging at it, they just put the bat down and go, okay, now it's time for us to take the field. That's because they're tied to those specific questions. That's why I say don't write out specific questions. Listen to the answer and feed off that answer, and be prepared enough to know what that witness has said before and what other witnesses say on the same subject. So another way to try to cross-examine effectively, in my opinion, is to set up some conflict between what they're saying as a government witness or prosecution witness and what you know has already been said by another prosecution witness before them, or you know another prosecution witness after them is going to say something that conflicts with it. So there's a conflict. You're creating a conflict. And then the jury decides which version is true. So I love to take a witness, and I like, if I've got a statement, you like to find a way to either get them to tie them to a statement. It's almost like tying them to a post. And that post can be a statement that they've made, a statement that another person has made, or a fact beyond change. True. And then you sort of have that person really, you have each person you can use against each other and talk about when witnesses contradict each other or witnesses disagree, that's a reason to doubt. This person said X, this person said Y, both took the oath, both looked you in the eye and said, this is how it happened. You know, I mean, the state just wants you to look at it and just say, oh, don't worry about the fact that our two most important witnesses can't agree on what color the light was. It was a light. That's a way to demonstrate what the meaning is for what reasonable doubt is. You've got two government witnesses saying opposite things on an important fact that's very important. That by itself can create reasonable doubt in your final argument. It should. Yeah. It should. Let me ask you something else. So I know that I know that each of us has certain parts of trials that we like, that we that we prefer. Some prefer voir dire, some prefer cross, some prefer closing. What part of the trial do you prefer the most? It's when the foreman of the jury stands up and says, we'd find the defendant not guilty. That's my favorite part of the trial. Okay, I like that part too. The two-word verdict. Yes, sir. So do you think cases are, because, you know, we read stuff in the newspapers, we watch shows on television with the big, you know, flourishing closing argument. Do you think trials come down to closing arguments?
I think most trials are determined during the introduction of the evidence phase of trial, but there are some cases that are so close when the evidence is closed that a really good or a really bad final argument can make the difference in a juror's mind. So to me, I don't know that there's a most important part. I think you ought to do your damnedest to be as thorough as you can at every single phase of the trial, including the final argument. And I don't think the trial ends with a verdict sometimes. I will tell you that we have in a military case in our office right now where my daughter, Terry, who is a colonel in the Marine Corps Reserve right now, and her military assignment is as a military trial judge. But as a civilian, she represents, and I was helping her on the case. We always have two lawyers on felonies. And there had already been a guilty verdict accepted, but there was an opportunity in the military to file post-trial pleadings. And we filed a motion for a post-trial declaration of a mistrial because of some misconduct that was discovered on the part of one of the jurors. Make a long story short, the trial judge did something that's almost never done and granted that and has ordered a mistrial. And the government's debating now on whether to retry the case or appeal. And we're in the appellate process right now, the government appealing the declaration of mistrial post-trial.
Jack, that's not your first, I don't mean to cut you off, but that's not your first save, if you will, of somebody who was convicted at a trial by a jury. You've had a number of cases, it seems to me, where you've actually been able to pull victory from the jaws of defeat.
That's correct. And thank you for saying that. If someone asked me what's my proudest moment, it was the time when I walked a client who had professed his innocence for 8 years while he was on death row, walked him down the courthouse steps and to freedom because we had got a federal judge to grant a federal writ of habeas corpus, where the federal judge was the uncle of the trial judge. No, not of the trial judge, of the state appellate judge who had upheld a conviction. And walking him out was really one of the proudest moments, because he clearly, in our mind, was innocent. They got the wrong guy, and we were able to fight it for a long period of time, and ultimately
he was on death row.
Yes, he was on death row. And if you don't mind, I'd like to illustrate something that will never leave my mind.
Please.
We booked him a flight back to Oklahoma, back to Oklahoma City, which is where he was from. And so we had to spend the night there because we couldn't get a flight back till the next morning. And I said, his name was Henry Bourne. I said, Henry, we're going to go out and you're going to have your first real good meal you've had in eight years. Where do you want to go? To steakhouse? I'll take you anywhere you want to go. So we went to steakhouse. So he took one bite of his steak and he couldn't eat anymore. And I said, what's wrong? It's a great steak. Is yours not good? He says, it's too rich for me. He says, I can't eat it. I'm going to get sick. He says, I've been eating that other food for all this time. I can't do it.
Oh my God.
And so when we were getting ready to go out, I watched him walk with me out of the restaurant, and I noticed his steps were like 8 inches at a time. I said, does your back hurt? He said, no, sir. I said, your feet hurt? No, sir. I said, why are you taking such small steps like that? He said, oh, I apologize. He says, I've had to walk that way for 8 years because I've had shackles on my ankles all this time. And now I don't have them. I still think I got them. And I almost broke into tears. But that was a satisfying thing. And also, while we're talking about some successes, we represented a young Lance Corporal who was charged with murder for an incident in Iraq. It was a military case. And what he did was his unit had taken fire from a particular house on a ridge that they could see, and they were taking fire from it. So they knew that there were enemy in there. And so the platoon leader had everybody do what they're supposed to do. And then they come in, and they had been taught how to breach a house and how to come in and clear a room. And this young lance corporal did exactly what he was trained to do. He saw movement in the bedroom when he came in, and he sprayed that area with movement. He knew that's where the fire had come from. What else is he supposed to do? He did exactly what he was supposed to do. So after it was cleared and they went back, then the people came in to assess and report back to higher headquarters, and they found a civilian who had been shot and killed underneath the bed as a result of that. So they charged this guy with intentional murder. And so, you know, we fought that, and we ended up couldn't get him to dismiss the case, showing there was no intent for him to murder this person. He was doing what he was training. Couldn't get anybody to listen to it. And then on the first day of trial, the case got dismissed because the commanding general, who had granted me an opportunity to talk to him, and I did. His name is General Mattis. The General Mattis.
General Mattis.
Went on to. He finally granted.
This is Bulldog Mattis, who is
yes.
I think he was the Secretary of Defense.
Yes.
Right.
Yes.
So
I thought that was one of the greatest misjustices I'd ever had. And having been an infantry battalion commander in the reserve myself, we teach young Marines to do what they're trained to do and to follow orders unless they're illegal, clearly illegal. Clearing a room is not clearly illegal. It's what they're supposed to do. That's all he did. And I tell you, one of the highlights of my career is calling his mom on the first day of trial and having her get on the phone and tell her that her son's free.
Jack, that's a really touching story. I mean, what an amazing story.
He's a great guy, still doing well.
You ended up, you also, I know, ended up at one point, you obtained, I believe you tried a murder case in which you ended up getting a not guilty verdict by a judge. I believe you were you, the story is walk me through it. So first of all, there was the case, the last name is Daniel.
Yeah.
Right?
Yes.
Tell me about that case.
Well, that was a very high profile case because Vicki Daniel was married to a fellow who was the former Attorney General. The deceased was a former Attorney General of the state of Texas, whose father was the former governor of the state of Texas and a justice.
Everybody's plugged in. This is as dialed in as you can get.
Yes. They owned half of the county. Okay. It was a rural county, Liberty County, Texas.
Okay.
And so she was charged with killing her husband, murdering her husband. And, you know, the evidence at trial is that he was an abuser, and she testified to that. And that affected some jurors. I will tell you, we found out later when they heard what he made her do, that really turned off a lot of the jurors. And the evidence is that he was having an argument with her because he couldn't find the marijuana that he had stashed in the attic, and he went up to the attic to look for it, and it wasn't there. And they had the fold down ladder, you know, where you climb up to the attic, and he was standing at the top of that, and he called for her, and he says, "Where the hell is my marijuana?" And she said, "I threw it away." So he came after her. He says, "I'm going to come down there and I'm going to kick the shit out of you." And he kicked her in the head and knocked her backwards. And it was right by the back door. And they always kept a loaded rifle in the back door because they lived in the country. So she grabbed that thinking that if she could show it to him, she would scare him and he wouldn't come down and kick her in the head again. But he came after her and he grabbed the rifle and pushed her backwards. She went through the door, but the rifle didn't go through the door. The rifle caught on the door jamb and pulled, and she continued back, including her finger on the trigger, and the trigger discharged the weapon. The weapon came and killed him. And so that was the offense was it was an accidental discharge, and it wasn't an intentional killing. It was a highly publicized case, and what happened on that was that we got a report after a weekend break that a juror was overheard in a grocery store saying that she would never vote to convict her because of how bad he had treated her all the way through and all the abuse, that sexual abuse and stuff that he had. And so that got back to us. That would mean it would be favorable. She never would vote for guilty. The same day, the state got somebody who overheard a different juror saying, she's guilty as hell. I'm going to vote for her, finding her guilty, and we're going to send her away as far as we can. That got back to the state, and we had a really ethical, honest prosecutor. So he and I exchanged that information, and we said, what the heck? If you got one that says, no matter what's going to vote one way, and I got somebody saying, no matter what, I'm going to vote the other way, we're going to have a mistrial because we're going to have a hung jury. I can tell you that Ms. Daniel does not want to go through another trial. And he says, the state can't afford to go through another trial. And they'd call 300 people to get 12. And we had a hard time getting a jury. So the alternative was that was suggested, and I don't remember whether he did or I did, said, well, we can waive a jury and let the judge, he heard the whole thing. They had brought in a visiting judge because no local judge wanted to take that case.
Right.
So that night I called Racehorse Haynes, who was my boss at the time in Houston. I said, they got this option of waiving a jury and going with this judge alone. The trial is basically over and he's heard the whole case. And Haynes says, well, we make our living trying cases to juries, Jack. I said, I know, and I generally trust juries more than judges because it's harder to persuade 12 than one. And I said, but in this case, I think it's a surefire mistrial. He said, well, it's up to you. You're there, I'm not. I'll back you on whatever you want to do. How has he performed so far? I said, well, Rich, I said, I called him Race. I said, every objection that I made, he's sustained. Every legal issue that I've raised, he's agreed with. He knows the law. He seems to be as impartial as he can be. I think we have a good shot at getting a not guilty. He said, then go ahead and tell him you're willing to waive the jury. So we did. We waived the jury. The state waived the jury, went to the judge. The judge announced his ruling after consideration. He says, gentlemen, I just can't get past reasonable doubt. He said, I find the defendant not guilty. So that was another time where the newspaper said, when we came down the stairs, they asked me to raise her hand like at a boxing match, So I got myself like a fool. I'm raising her hand up in victory. I'm walking down the steps, and that's the picture that the newspaper used.
I want to see that picture. That's a great picture. I love that picture.
That is, and it was on our wall for a long time in our office.
Jack, let me ask you a couple of questions. So I want to ask you a question about Racehorse Haynes.
Yes.
Every other interview that I've done with some of the great lawyers in this country, of which you are a member of that class, bring up Racehorse Haynes as the best trial lawyer or the best cross-examiner they've seen. I don't have the pleasure to have known him or to have seen him. Tell me about him.
Well, I worked with him for 6 years, and he and I tried all the big cases during that period of time. I was the lawman for him, and he was the lead counsel. But he always asked me to help prepare the cross-exam of every witness, but he did it. And I just lost your picture. I don't know if that's, there you go, you're back now. He had an uncanny ability to get under the skin of a witness. He just was so folksy and so non-threatening, but he just, he could cross-examine somebody for 2 hours on where they went to dinner that night. He just was so thorough, and his style was so that he would get them to really like him, and then they'd tell him whatever he wanted them to tell. And so he's the best cross-examiner that I ever personally saw. And he was probably the best trial lawyer in general. His final arguments, I learned a lot from him. Now, when I came to work for him, I'd already had like 300 trials under my belt as either a defense lawyer in the Marine Corps, a prosecutor in the Marine Corps, as a trial judge in the Marine Corps. So I'd seen a lot of cases and done a lot of cases and watched a lot of cases from the bench. But he was probably the best trial lawyer that I've ever seen.
When did he die? I mean, I know he passed away, but did he die still practicing, or did he retire and then pass away after that?
He got ill toward the end of his life and was bedbound for a while. So but I remember there was one case where when he was like 80 something years old, and it's a story that went around in a small city north of Houston, where we still would represent people because it was not that far a drive. That he would be seen parking his car in front of the county courthouse there, out in a little square, center square of this town, and be walking up the stairs to try a case in his 80s. So he tried cases till right before he got sick, and was still sharp as a tack. We had a lot of good times together, and I learned a lot about perseverance from him, even though I thought I had a good stack of that already. You just couldn't help but like Racehorse Haynes.
Jack, tell me, there are some legendary lawyers who seem to have come out of Texas. There's obviously you, Jerry Goldstein, Racehorse Haynes, obviously. There was a guy years ago in a civil case. I used to hear about this guy named Steve Sussman, who was, I think, a well-known guy from Texas.
Mm-hmm.
Joe Jamila, is that Joe Jamila?
Joe Jamil won a lot of civil cases.
Another guy who does huge civil cases down there, Mark
Lanier.
Mark Lanier.
Yes.
What is it? What do you guys got something in the? You got something in the water there?
I was going to say, I think it's the water. No, I don't know. I think it's just hard work. And, trial lawyering has there is an element of luck in trying cases. I mean, some things are beyond our control. Like when somebody confesses on the stand to have some kind of horrific background that you didn't know about and destroys their testimony. You can't control that kind of stuff. That happens rarely, but it does happen sometimes.
Have you ever had a moment like that, Jack, where you've had someone on the witness stand and there's a Matlock, Perry Mason like moment?
Well, I think that the closest thing to that was a murder case where the jury was deadlocked in this country town, and judge was considering sequestering them overnight, and so he called in a couple of this isn't on cross-examination, but it's something that was unexpected. The judge called each juror in and asked them about their view, wanted to find if somebody was really going to object to being sequestered overnight in a hotel. He was not going to do it. So this one young woman who was on the jury was asked about what her thoughts were spending the night in a hotel so they could continue and he didn't have to declare mistrial. And she said, well, sir, I don't have any objection to it. She said, but there's only one other woman on this jury. He said, I don't know what my mother would think about me spending the night in a hotel with 10 men. So everybody, how could you not start laughing about something like that? But that was the only unexpected thing that I've ever heard a juror say that, and he went ahead and sequestered, and then they finally came back with a knife.
Do you watch the jurors during your trials, Jack?
I do.
Tell me, how do you do that? Because I know that's something that I do, and I also have co-counsel there, commonly watching the jurors, not staring at them, but trying to see what is trying to take the temperature of the jurors as things are happening.
I think it's invaluable and indispensable to know what you think. And that's what I think the difference between a young, inexperienced lawyer who's just starting out, and everybody's that way, and the experienced lawyer is being able to read jurors. In fact, I think that ability to read jurors goes on to other areas of life other than observing jurors. I think I can tell when a salesman's BSing me. I think I can tell when somebody on television is testifying in Congress or something and know that they're not telling the truth, because I can read body language and stuff like that. So I do watch the jurors. If I see a really negative reaction to a statement of a witness on the stand, I make a note that witness number 6 or something like that didn't like the answer given by the complaining witness. And sometimes especially when a jury's been out a long time, you're trying to figure out what to do, whether you want to ask for a mistrial because the jury's hung and you'd rather have a chance at another trial. What else can you use to inform yourself about where you make that motion other than what you think the jurors are doing? Like if you see there's a dispute between the juror on the left top side and the one on the bottom right side, every time one of them says something, the other one disagrees with it or has a frown or something like that, then there's maybe, now that there's the old joke about if it comes over lunchtime and the bailiff is taking the orders of I always ask the judge to ask the bailiff to tell us what it is, because you're looking for the case where there's somebody that orders a jury that orders 11 hamburgers and 1 hot dog. That's an indication that maybe there's something there, So yes, I do look at the jurors.
Love it. Love it. Love it. That is great. I've always tried to tell young lawyers when they ask me where the trials start, I always tell them that my trials, my voir dire starts as I'm driving to the courthouse. And I'll tell you what I mean by that. The person that you cut off in the parking lot, the person who you turn in front of, or who you're tailgating, or you're honking at, or you're texting while driving in front of or next to, or you park too close to, or you jump in front of in line, or you talking badly on the phone to somebody as you're walking in, any one of those people around you could be a potential juror.
Exactly.
And then when you walk in the courtroom and you try to be I get along with everybody type person, they remember. Maybe they don't remember right away, but they might. They might remember that you were the guy that did that.
Yes.
And they're probably not going to raise their hand and say, yeah, I know that guy. Zimmerman's the one. I saw him walking in. He was calling someone an MF on the phone and cut me off and was texting and driving.
Yeah. Yeah.
They just have in the back of their mind that, that was that guy.
Yeah.
It's an amazing business, an amazing, Jack, I want to ask, so I could probably talk to you for 3 hours, but I don't want to take up that much of your time. I do want to ask you a couple of questions about, I think that you have all of the awards that you have been given or honored with, all the accolades that you've received are fall short, I think, of really paying homage to what you've contributed to your community, to the country, and to the legal system. So those are not hollow words on my part. I mean that. For those who don't know, I got a bit of the reason I say that is I got a little bit of a dressing down from Jack as we were preparing for our talk. I got caught up in a couple of days where I had encouraged him or committed to having a conversation with him to go over some things, because he was he's wanted to make sure everything was done exactly right and everything was in order and all the the I's were dotted and T's were crossed. So 2 days in a row, I missed the window to talk to him. And when I talked to him on the phone yesterday, I said, well, we can do it now. And he goes, I blocked off my whole afternoon for you. I got people that are here to try to help, that I need to help. And I'm sitting here twiddling my thumbs because you can't get on the phone. And I respected that. And I imagine that you in court talking to a witness or a police officer or a prosecutor, and I imagine you using the same sort of, you didn't yell, you were just firm and you were respectful. But I walked away from it thinking, this is a man that is, my time is not more valuable than yours. And I came away thinking, I'm looking forward to talking to you. And then I read your resume and all about you as much as I could, and I've come away even more impressed. So let me just own that. So I do apologize for not being as prompt as I should have been. You deserve that.
Okay, not guilty.
All right. Let me ask you, what lies ahead for you? I like people who want to learn more about Jack Zimmermann. It's 2 N's, by the way, on the end of his name. People who want to learn more about you, where can they go? Let's start with a website. If they wanted to learn more about you and your firm, how could they find you on the internet?
It's easy. We have texasdefenselawyers.com.
Okay, easy enough.
Texasdefenselawyers.com. It's our website. And by the way, I would be remiss if I didn't let you and your viewers know that nobody achieves success by himself or herself. And we've got a real team here. And I've been lucky to have a partner, Jim Levine, since I joined the law firm of Haynes and Fuller and Wider in 1978, stayed with Racehorse 6 years, and then opened my own firm. And then the next year, Jim Levine left the DA's office as an undefeated prosecutor and came as an associate and worked for about a year or so. And I said, this guy I've got to keep. We've been partners ever since then. He's one of the best lawyers in the country, former president of the National Association of Criminal Defense Lawyers. And Terry Zimmermann, who's, I will, in all openness, she happens to be my daughter, but she's the branch of the law firm. And she's a full colonel in the Marine Corps Reserve right now. And she's on every felony case with me or with Jim. And she's made a name for herself, especially in the military law, civilian practitioners in military law. So the 3 of us are together. And then my wife of 57 years now, just went over 57, Eileen, has also served. We were married for a very short period of time when I was ordered to Vietnam. So we were separated for about 26 of the first 48 months of our marriage. And she and I have been fortunate to be able to raise 2 very successful and dedicated citizens, if you will. Terry's, as I said, a Marine Corps, a reservist, and in our full partner in our law firm. And David is a senior supervisory special agent with the FBI, stationed with the U.S. Embassy in Tel Aviv, Israel. And he is a former Marine pilot, or navigator actually, in the F-18s. So both of our kids have contributed and are contributing now to the nation's welfare. And we have 4 grandchildren who are all brilliant and successful in their own right. So we think that Eileen and I have lived a life that's full, and I have to give her credit. She's the glue that's kept everything together, and she's so smart. It's hard to believe someone that smart is that cute. So I just want to mention that while I have.
I appreciate that. Jack, it has been an honor to talk to you. And I do think you've earned every accolade that you've received. And I'd be remiss if asking, I'm not sure, what was that double date like with Jerry Goldstein back, what was that, probably 40 years ago?
I don't know, but I was driving and it was hard to keep my eye on the road instead of the rear view mirror, watching what that guy was unsuccessfully trying to do back there. But he's gone on to be a really outstanding leader of the defense bar throughout the country, and he's a good guy.
And I know your good friend Dick DeGuerin is currently in quite a battle in California, representing Robert Durst. I don't know if you followed that trial at all, but he's they're battling out there. I
have the greatest respect for Dick and his wife Janie. They're good people.
So Jack, thank you so much. Jack Zimmermann was my guest. A very honored and esteemed guest, distinguished guest on this episode of Killer Cross-Examination. I'm Neil Rockhind, and thank you for tuning in.